overview of the tenant's rights regarding repairs and habitability in their housing?
Sure, tenants are by law required to have habitable housing. Landlords have to provide that. We actually brought a pamphlet, hopefully you guys will take some of those that list all the tenants' rights in there. Let's say for instance, we have a lot of issues with repairs, like we said. If there's something in your home that's making it unlivable, you have to provide what's called a 14-day letter. We also brought some of those and you can fill them out. So basically the 14-day letter is telling your landlord, hello, Mr. or Miss So-and-so, this is what's going on in my apartment and I'm giving you this notice to fix it. Your landlord has 14 days to get it fixed. In the event that they fail to fix that repair or make that repair, you can legally break your lease. However, if you owe any rent, you still have to pay that rent. But you can break your lease legally if your landlord fails to make those repairs within that 14-day time frame. A lot of people don't know that, so if you want to take some of those sheets, please do so, because it's very important. And a lot of landlords, they won't fix things, but you want to always get something in writing. That's why the law requires that 14-day letter, because you can tell your landlord anything. So if you have a letter showing that you gave them the letter, it's dated, what the repairs that need to be made, take a picture of the letter before you give it to them. That way you have a timestamp that I provided this letter to so-and-so on this date, and you can start the clock for the 14 days.
Just jump in with, add to what Christina was saying. In Alabama, you can't stop paying your rent because the landlord won't fix anything. A lot of people say, I didn't pay my rent this month because the landlord won't come in and fix the leaking roof. So, and then sometimes it's not feasible for people to move. If I give the landlord a 14-day notice and he's saying, I'm saying either you fix it or I move, I may not be able to move. But a lot of times you can sue the landlord for the reduced rental value. So if you're paying $1,300 a month and you got a leaking roof in the living room, or you can't, if you tried to rent that property out, you probably would not be able to with a leaking roof, but you can sue for reduced rental value, for the reduction in the fair market value for the rent.
Can you clarify, is that also after you have paid for said repair?
Yeah, I mean, if you pay for the question. So she's saying if you have to pay for the repairs out of pocket yourself because the landlord won't, is correct? Is that what you're saying? Can you sue for that money back that you did to make the repair?
I'm asking, when you made that statement, were you saying in the instance of the repair being paid for by the tenant, then you can in turn sue the landlord for said money?
Yeah, of course. Now, just think about it. If you damaged something in the property, and it was and the landlord had to fix it, he wants you to pay for the damage in that property. So you have equal rights. If it's something that's the landlord's responsibility to fix, and he will not fix it, and you have to pay to get it fixed, then you can also demand to have your money paid back also. A lot of times tenants don't know they have the rights that they do. Of course, Alabama tends to be, in my opinion, tends to favor more landlords. The laws are landlord friendly, but tenants also have rights that they don't know they have. So, but yes, you can ask for your money to be refunded or returned to you, or you take it out the rent, or however. You just can't do it yourself.
Okay, many survivors of domestic violence face difficulty finding or staying in, not evicted, from housing. Can you please explain how the Violence Against Women's Act provides protection to those survivors?
Okay, the Violence Against Women's Act, and I'll say VAWA, just to make it or the Act is how I do it. So in 1994, I believe, then President Biden was behind this push to get an act to protect women of domestic violence. So that's how this act came into being, and it gets renewed every 5 years. So, and it was designed for housing matters, is to get people, or women, men, whoever, who are victims of domestic violence, to get them to come forward about the violence and not be afraid of losing their housing benefits or their Section 8 voucher or something, because they're in a a relationship where really it's criminal activity because it's a crime to domestic violence, or sometimes the offender is throwing stuff, breaking stuff, damaging property. So it's a way to get them to come forward and to talk about domestic violence, or to prosecute the offender without having to fear losing their voucher. One thing I would say, a lot of times we have people who qualify for different protections under different federal laws, because it mainly is talk about people who are public housing, who get housing, Section 8 voucher, and you'll have women who say, well, you know, I'm in this domestic violence relationship, now my landlord is evicting me because he kicked out the door last night, but she's not in public housing, she doesn't get a Section 8 voucher. But then you have to look at, well, does the owner of that property or the inner tenants that get Section 8 voucher, do they receive any money from HUD for other tenants? So then those rights will extend to that other victim also, even though they don't have a Section 8 voucher. This landlord do take Section 8 vouchers from other tenants, and he gets federal money. So they will still have those same protections. So that's something to share with clients, because a lot of times they don't know, they don't, just because they don't have those vouchers. So I would say, what protection do they get upon VAWA protects survivors regardless of their sex, gender identity, or sexual orientation, and regardless of the sex, gender identity, or it doesn't matter if you're a victim of domestic violence. So who does it protect? So what does it say? You cannot be denied admission or assistance. You cannot be evicted from a HUD or somebody who receives federal government money. You cannot be denied admission. A lot of times you have people who, I had one client who, a boyfriend came over to the house and he physically abused her. He kicked in the door to get to her, and then her landlord was evicting her. And so we had to go up under the VAWA, up under the act, to say, no, she's a victim of domestic violence, you cannot evict her for some criminal activity that took place on and she had no part of. So when we was able to stop that eviction from going forth and save her housing. So, and you can request a bifurcation of the lease, meaning if both you and the offender, if both your client and the offender own the lease, you can force for them to remove him from the lease and from the premises. So, there are many protections that are available to victims of domestic violence. I think the main thing to take from that, the main thing to remember is that it protects them. It protects their housing benefits. It protects them from being evicted. It protects them from losing their housing vouchers. It gives them a preference if they need housing. So if they need a housing voucher, if they need to obtain private housing, to keep them, it's designed to prevent homelessness in the victim of domestic violence. So if you have a client or you know someone who is a victim of domestic violence, the man kicked them out the house, or they don't have anywhere to go, there's a form that is a form you fill out. It's a HUD form, and I can't remember I can give you the form number. But it's the HUD form 5382, and it's called the certification of domestic violence. And they can fill that out. They can file it with their application when they're applying for housing or Section 8 through the Housing Authority, and it gives them a preference, and it also requires them to look at them for emergency housing, emergency placement.
Okay. Sandra, is domestic violence survivors also protected under the Fair Housing Act?
Possibly, because statistics show that a lot of the victims of domestic violence are women, women with disabilities, or women of color. And so those are some of the protected classes that fall under the Fair Housing Act. So under a lot of the municipalities and housing providers, they'll have in their leases certain stipulations about, nuisance, disturbing the peace and those sorts of things. So if there's a domestic violence situation, it would have to be done on a disparate impact, formula, where you would look at, like I said, the statistics showing that there's a disparate impact among, African-American women or women with disabilities, those types of people that would fall under the Fair Housing Act, so it depends.
What can a person with disabilities do if they are having difficulties in their home or in finding a home due to policies of the housing provider? And what process, if any, do they need to follow?
I'm sorry.
Okay, what can a person with disabilities do if they're having difficulties in their home or finding a home due to a policy of the housing provider? And what process, if any, do they need to follow?
Okay, so, we talked earlier about, requesting a reasonable accommodation. So it would depend on what the issue was and what that person is looking to have happen. So, for instance, again, if there's a parking situation where that person wouldn't have, easy access to the facility, then they can request a reasonable accommodation, for designated parking. If they need, a grab bar in their bathroom, then they would request a reasonable modification to have that grab bar installed. So it would depend on what the issue was, but basically they would just need to, request a reasonable accommodation. And there are, they can do it orally, but the suggestion is that everything in writing, stated in writing, so that, because they'll have a certain amount of time to provide access to that before, there can be a housing complaint filed. So they'll have to be given time to provide that reasonable accommodation. The joint statement says, I think reasonable time would be around 10 days. And so to make that provision. But, so we asked them to do everything in writing so that they'll have that time frame, and they'll, if we do need to file a complaint, then we'll have that documentation that they did make the request, they followed the procedure. Again, it doesn't have to be in writing. They don't have to say reasonable accommodation, but we strongly suggest that those buzzwords are used so that there can be no, misinterpretation of what this person was asking for.
So many Alabamians are struggling to find affordable housing. Are there any limits on security deposits or fees, like, application fees, pet fees, cleaning fees, etc., that landlords can charge a renter?
When it comes to security deposits, it can't be more than 1 month's rent. That's the law here in Alabama. As far as the application fees and pet fees, those are kind of discretionary. They shouldn't be punitive, but again, the law only speaks to the security deposits, and it can only be up to 1 month's rent.
But I think they would look at what is reasonable, and it has to be objective, not subjective. If you charging an application fee, or if you charging, some type of fee, just think about what is reasonable under the circumstances. So it has to be a reasonable fee, and it can't be punitive, meaning it can't punish the client. So I think that's what the court would look at when it comes to something of that nature.
Many leases contain a clause limiting criminal activity or violence on the property. Can you explain how that may negatively affect survivors of domestic violence and what can be done to overcome that obstacle?
I think that's where the VAWA comes in. Let me see. I guess how it would negatively affect victims of domestic violence is it would be actually criminal activity taking place on the property. And with victims, I would say they're more if the police come out and an arrest is made or charges are later filed, then it's against the perpetrator or the offender and not the one who is a resident in the property, but that it negatively affect you if the landlord is not a recipient of any type of federal funds. It's a private landlord, and this is criminal activity that has taken place on the property. It does allow, in certain cases, where you may be given more time to move, and more time to find other housing. But unfortunately, if it is not a recipient of any type of federal funds, then you don't receive those protections on the bond. And that's why I said I always look at the landlord to see if they're staying in a housing unit, even if they're in a housing unit, look and see if that landlord received any type of federal funds for any other tenants, or any type of federal funds.
So are landlords allowed to deny a request for an assistance animal or charge fees for the animal?
Generally, no, but as with most things in the law, it needs a little bit of expounding of mind. If you have a certified emotional support animal and the landlord does not want to allow animals on their property, you cannot be subjected to extra fees, cannot be evicted for the animal. And when you initiate a lease where everybody has the understanding that there's an emotional support animal involved, usually there's not a problem. The problem comes in when you have an existing lease and then you bring the animal in to a landlord who said absolutely no animal. Well, there is a reasonability factor to the emotional support animal. Generally, the landlord cannot say no, cannot evict you for it, cannot charge you fees, but you can't just go to the farm and adopt an emotional support pig and then download a certificate off the internet. In some states you can. Colorado, for example, you can just declare an animal as support and then the landlords are stuck with it. But here in Alabama, it's reasonable. There's a reasonability of like if the animal would be expected to like damage a property, what animal would be expected to be a reasonable support animal, and then also it has to be a legitimate certification from a health professional saying that the animal is necessary.
Would you like to add anything?
Well, just kind of what he said,